In the United States, a valid will must be in writing, signed by the testator, and witnessed by attesting witnesses. However, in certain states, a will that doesn't strictly comply with these formalities may still be considered valid if the decedent clearly intended for the document to be his or her will. The leading case of this so-called harmless error rule is In re Estate of Hall. In 1984, James Hall executed his first will. But 13 years later, he decided to replace his first will and execute a new joint will with his wife Betty. To accomplish this goal, Hall contacted his attorney, Ross Cannon, who prepared a draft of the joint will and sent it to Hall for review. Hall and Betty met with Cannon at his law office in 1997 to discuss the joint will and, after making several changes by marking up the document, mutually agreed on its terms. At the end of the 1997 meeting, Hall asked Cannon if the draft could stand as a valid will until the document was finalized. Cannon advised Hall that the draft would be valid if both Hall and Betty signed the draft and Cannon notarized it. Hall and Betty then signed the draft of the joint will, and Cannon notarized it without any witnesses present. When Hall and Betty returned home, Hall asked Betty to destroy his first will, which she did. On October 23, 1998, before the final version of the joint will was executed, Hall passed away at the age of 75. Following Hall's death, Betty applied to informally probate or administer without a hearing the joint will. Hall's daughter from a previous marriage, Sandra, objected and requested a formal hearing to admit Hall's first will to probate. After a hearing, the district court admitted the joint will to probate and Sandra appealed. The Supreme Court of Montana agreed to take the case.